Calling case 16-2471, United States of America versus John Benchick. Oral argument not to exceed 15 minutes per side. Mr. Laughlin for the appellant.
Good morning, Your Honors.
Good morning.
Paul Laufman on behalf of Appellant John Benchick. May it please the Court opposing counsel, I'd like to reserve 5 minutes for rebuttal.
All right.
Your Honors, we have several topics we could and may reach today. Sufficiency of the evidence, some evidentiary issues, a unanimity instruction that was missing in regards to a duplicitous indictment, some sentencing questions, and ultimately restitution. But with the Court's willingness, I'd like to start with sufficiency. This case on its face may appear sufficient. It was a 6-week trial. Evidence was heard. A jury decided. But, Your Honors, we really need to step back and take a look at this case in its scope and in its context. Because at its core, this case is about wrongfully inferred and legally insufficient proof of intent. The government's case against Mr. Benchick is based almost entirely upon the notion that he, and presumably along with his parents, were filing false residential mortgage applications. And they take issue with 3 primary notions: the notion of income, the notion of residence, and the notion of...
Let's just start with income.
Thank you, Judge. Yes, ma'am.
Your client, it appears by all that's right and holy, told some whoppers about income. I mean, gigundo whoppers, which is apparently how he pulled it off. He said, I make $750,000, something like that.
Judge, I think that respectfully comes back to the context in which I was referring to. John S. Benchick, my client, and his father, John I. Benchick, had for years and years been highly successful real estate investors.
Where's any proof of that?
They put Mr. Benchick on the stand, who went through starting from 2002
This is your client's
forward.
testimony.
With documentation. His attorney went through him with contract after contract, deal after deal.
But where's the deal after deal? I didn't think, counsel, I'm sorry, but I didn't think that the evidence included, and we know the jury didn't buy it for whatever reason, but I did not think the evidence included following the deal to cash in the bank.
It comes down to...
Other than the cash that came through these so-called deals.
Well, there was a lot of cash out there, Judge. I mean, let's remember, all of these deals were funded by massive down payments. Some of the original loans, for example, the original purchase of the Beck Road property in Count 2, that mortgage was paid on for a year, regular as rain. The Benchick family had significant income from real estate investment. Now, I think the crux on the income side comes down to, Judge, this use of anticipated income. And the government's only proof on this issue, and again, we tried in our briefing to put into context the time of the real estate crash of 2008. I mean, Washington Mutual, because of the conduct that got them into this case, crashed. Because at the time, according to the witnesses at trial, they were accepting these no-document anticipated income stated loans, where somebody filled out essentially, here's what I expect to make. Mr. Benchick called as a witness Mr. Wicker, who talked about the underwriting credentials, what was happening, said stated income loans were the norm.
Did your client say, admit his tax returns into evidence?
He did not, Judge.
Did he show anything about what was actually in his bank accounts?
He did not, Judge. This was what he did show, and I think his anticipated...
What he showed was some contracts?
Yes, anticipated deals, again, with legitimate individuals.
Did he present any evidence that they went through?
In fact, they did not go through, Judge. That was the problem. They were supposed to close, generate millions of dollars, and in the type of real estate investment he and his father were involved in, that often happened. They talked about multiple deals that got right up to the day and crashed. I kind of think that was the nature of the beast. But when they had...
The problem here today is that a jury was presented with all the arguments that you're bringing forth, and they said, nope. And we can't we can't change that. So
And-
you would need to focus on some error of law, right?
Judge, I think within the sufficiency realm, I absolutely agree. I'm not asking this court to second-guess the jury. I'm not asking you to say they just got it wrong. But I do think that based upon the totality of the evidence, it was legally insufficient. There just was not enough there for them to infer the criminal intent they did. I mean, that has to be the core of our
Other than-
insufficiency argument.
Is there an argument you can offer today that would narrow that scope? A particularized legal insufficiency of a particular element that wasn't presented?
Judge, I think the element has to be intent, and the intent has to be drawn from the court's focusing on income, but I think we could focus on residence and employment and things of that nature. But at the end of the day, the Benchicks made their money from real estate investment. They had these two companies that they
The jury
used.
looked at intent.
The jury looked at intent. That was
The jury decided against your client on the issue of intent.
They
Having
did.
heard all that evidence, is it 6 weeks trial?
Six.
Whew. So they didn't agree with the argument you're presenting
They
today.
obviously convicted, Judge, but I think there's a sufficiency argument based on questions of law that are above and beyond.
Okay, and the intent
Where we
is
are.
the one you would tell us that we could help you with?
Yes, intent is the element this court should look at for the reasons, and quite honestly, Judge, it's one of those areas where it's briefed, it's out there. I don't know that I have anything more succinct to add today. But let's turn to an interesting question of law if we could, because I think the duplicitous indictment and the lack of a unanimity instruction is a very intriguing one. Many times in criminal cases like this, error is caused by the same factor, the government overreaching, the government
Not
choosing
remembering
to pursue.
with regard to unanimity, whether or not an objection was brought to
It
the
was
court's
not, Judge.
attention.
We
Right,
own in
so
our
we look at that
brief-
plain error.
We own in our brief that this was plain error, but an incorrect jury instruction is plain error, is an error of law. So I don't know that the standard would have changed or our hill is any higher to climb. But at the end of the day, this all began because the government just couldn't help themselves. They had a nice, clean 4-count indictment on real estate fraud. They had to supersede. And even if they wanted to add this notion of the fraud related to Mr. Knorr up in Michigan and the property down in Florida, they couldn't help themselves from adding in this concept of the BEV, this electric vehicle. And in the indictment, it clearly goes to both. In paragraph 14 of the superseding indictment, it lays in about how Benchick also was working on a new electric car invention and convinced Knorr to invest in this. And the evidence was adduced at trial. There's one line on the verdict sheet. Do you find him guilty or not guilty in count 5? And the jury instructions simply outline the fraud elements and say, do you find beyond a reasonable doubt that he defrauded Mr. Knorr? There is never a question of, do you find he defrauded Mr. Knorr in regards to the real estate investment or the BEV? And at the end of the day, we simply...
Does it affect his sentence in some way, counsel?
Absolutely, Judge. I mean, he was convicted of count 5. I mean, I think every citizen has a
I
right...
mean, under the guidelines, did you outline for us how that he would have otherwise warranted 10 years less?
Judge, I don't know that he would have warranted 10 years less.
Okay, that's where I'm looking at. Does it affect?
Under the guidelines, I don't know that it would have changed a guideline. I can't say that in good faith. But we do know that under 3553, a sentencing judge is taking into consideration all factors, the guidelines being just the starting point. And there is no doubt that the judge relied and mentioned in his sentencing colloquy multiple times this notion of, and this ongoing fraud, and the government made an issue of and got an enhancement for the fact that some of this conduct even occurred during the pendency of the case. So I think it's beyond question that the district court took this into careful consideration when crafting its sentence. So, do I think resentence is warranted? Absolutely. And we can't say, sitting here right now, did 6 jurors feel he was fraudulent about the BEV, or did 6 jurors find he was fraudulent about the real estate? We just don't know, and that's the very core.
What we know is they found fraud with respect to Mr. Knorr.
Correct. But under which theory? And that's the whole point of a duplicitous indictment. When you bring forward two theories, you don't get two bites at the apple. There has to be unanimity on one theory or the other. The government could have put those in two separate counts, and maybe they would have rung the bell twice. Or maybe the jury would have said yes as to one or no as the other. But they didn't do it. Nobody sought it, and ultimately the trial court's responsible for the jury instructions and it being a correct statement of law, and here they were wrong. So we think count 5 needs to be struck, and the sentence set aside, and the matter needs to be resentenced on that issue. I see my original time is up, Your Honors. I'll, by necessity, save anything further for rebuttal. Thank you.
Thank you.
Good morning, Your Honors. Brandon Helms on behalf of the United States. I'd like to start, Your Honors, with the unanimity instruction that counsel just was arguing about. And he said that the government couldn't help themselves from adding the count about the BEV. I think it's better phrased as the defendant couldn't help himself. He was indicted and arraigned on counts of bank fraud in July 2013. After that point in time, he needed additional funds. So he started to con a Michigan farmer, Douglas Kinnear, to invest in to buy the house in 25 Sunset Bay and start paying for repairs for it, or allegedly paying for repairs for it, as well as invest in the electric car battery project called BEV.
But this doesn't address the unanimity.
Correct. I'm about to get to that, Your Honor. It's not, the schemes are intertwined. So the standard here is whether the alternative specifications are only marginally related to each other. And in this instance, they're not marginally related, they are intertwined. They can't be separated. What the defendant did was he found in Doug Kinnear a person that he could fleece for money in any way that he could. And the two ways that he found were most successful were by getting him to invest in this house and start paying for alleged repairs, and then also in paying for the car battery project. So Douglas Kinnear testified at length. He testified about how every time he spoke to the defendant brought up the proposal to invest not only in the house, but also to invest in the electric car battery project. He said every single time he talked to him about it, they were both brought up at the same time. There was also testimony from the accountant for Doug Kinnear, James Drukowski. He testified that he met both with the defendant and with Mr. Kinnear on 2 occasions. On both occasions, the defendant brought up both projects simultaneously. In addition,
I'm not sure I'm with you on why that matters. Why his tying, each time he's speaking to the victim, he's pairing them. How does that aid the government on the duplicious?
because they're not separate schemes, Your Honor. Under the case law,
That's how you're tying them because he tied them in his efforts to gather money.
exactly, Your Honor. Every time we tried to get money from Doug Kinnear, it was through the use of these 2 related schemes. And in fact, Mr. Rukowski testified at record site 118, page ID 2230, that in addition, Mr. Benchick's proposal was that if they were able to sell 25 Sunset Bay and Doug Kinnear was to get a project, he was to reinvest that money into the BEV project. So they weren't separate ideas.
Well, how did Judge Cleland instruct?
Judge Cleland instructed, well, there was no objection to it at the district court level.
We've agreed on that.
Right. The district court at the sentencing found that there was sufficient...
How did he instruct? Do you know? Did he instruct on 2 different, separately, the electric car and the house?
He did not instruct separately.
Okay. How was it? I don't know. Do you know how the court spoke about that count? I'm asking you just because counsel seems to say it was a significant difference and the jury had to come to a conclusion, unanimous conclusion with regard to his guilt on the house versus the electric car battery. What do you say to that?
My recollection, Your Honor, is that that's not how the court instructed. The court instructed that these are the facts of the count, and if the jury finds that these acts occurred...
Blends it.
Yes.
Like as you're arguing here.
Yes, Your Honor.
We'll check it.
As to the sufficiency of the evidence and the intent prong, As the court here knows, the standard is whether no rational trier of fact could have found could have found the defendant not guilty. And as to intent, I agree with Judge Cook that these were some gigunda whoppers. Besides the lies about the income, the defendant himself said he made $720,000 a year, when in fact his 2 years prior his tax returns reflected negative incomes. For his parents, he listed within a time frame of November 2006 through September 2007, he had them living in 4 different houses, and he had them intending to live in 4 different houses. He had them working for shell companies called Covey and Associates and Stanley Irvin and Associates, when all of the evidence at trial, or the overwhelming evidence at trial, was that they were retired. In addition, the father had dementia in 2004, and there was a note by his doctor, Dr. Randy Kay, as well as testimony from Dr. Randy Kay that he had severe dementia by 2004 and could not understand real estate transactions by 2006. Finally, there was some testimony from the mother, Helen Benchick, that the reason they ultimately didn't move into those houses in 2006 and 2007 was because the father had a heart attack, and that changed their plans. But the heart attack happened in 2006 before any of the 4 mortgage applications were filled out. So if that was the reason why they decided not to move into these houses, there would have been no reason to lie on these applications. So as the court has noted, that the jury heard all these explanations and rejected them. So unless the court has further questions for the government, I will sit down.
Well, one thing about all this, it would seem that these misrepresentations could easily have been ferreted out and identified by the banks as a part of the mortgage application review process before approving these mortgages. What did the proof show as to why the banks purportedly, if they failed to do their due diligence or review the information in connection with the mortgage application, why was it that the banks didn't do that?
Well, Your Honor, I agree that if a thorough review had been done, these might have been flagged. There's no way to know that for sure. But back in this time frame, 2006 and 2007, the standards were different from what they are today after the mortgage crisis fallout. So back in 2006 and 2007...
But this was a substantial sum. These were substantial sums of money that were being approved for these mortgages.
They were, Your Honor, but at the time, the practice was to still, the banks accepted a stated income mortgage application. So if you said that this is what you made, you were required to tell the truth. And in fact, on the form you signed, the Uniform Residential Loan Application, the defendant signed that he was filling out these statements correctly. So that was the practice at the time. And the law in this circuit holds that under United States v. Winkle, 477 F3D 407 at 414 note 3, this is a 2007 case, the victim of a bank fraud is the bank, not the CEO of the bank. And approval of a bank officer does not relieve a defendant of liability for bank fraud. There's 2 other cases as well, United States v. NIP, 963 F2D 839 at 846, and United States v. Bowling, 619 F3D 1175 at 1182 note 3. So as this circuit has made clear, there could have been explicit approval by a bank loan officer for these types of lies, but that does not absolve the defendant of the lies that he made in fraudulently inducing the bank to grant these mortgages.
All right, thank you.
I've been looking at the jury instructions as you were talking, and they're a little unusual in my experience, in that the district court apparently did not incorporate a reading of the indictment into the jury instructions. And when you get to count 5, he's merely treating the count 5 as alleging a single scheme to defraud. And that would be consistent with your position, correct?
Correct, Your Honor.
But it's really not a case where there are 2 separate means of committing a fraud, but rather just a single scheme which had a couple of different factual parts to it. Have I got that right?
Correct, Your Honor. The scheme was the defendant was trying to get money from Doug Kinnear in any way that he could.
Yeah, I mean, I understand that. And the fact that he tried to do it in two different ways factually doesn't mean that a unanimity instruction is required. Is that
That's correct, Your Honor. Because these two schemes were intertwined. They weren't marginally related is what the law requires. Thank you.
All right, thank you.
Judge Clay, I'm going to take your bait and wander back into the morass of sufficiency of evidence, but only to the extent that I think it sets the tone for our restitution argument, but also really puts into stark contrast Mr. Benchick's mindset based upon the realities of the banking industry. We cited in our restitution case to the Seventh Circuit Litos decision, where the court speaks powerfully about banks' deliberate indifference to a palpable risk. Now, I agree with counsel's statement that a bank's indifference to such a risk may cause them the clean hands to not deserve restitution, but it also sets the tone for the realities of the banking industry in which Mr. Benchick found himself.
banking industry is not on trial?
I agree,
Client
Judge.
is.
I agree, Judge. We can debate whether they should be, but you're absolutely right. For today, Mr. Benchick is on trial. But the point I'm trying to make, Your Honor, is we're talking about Mr. Benchick's mindset. This case is all about crime. It's all about a malicious intent. It's all about this desire to defraud. You know, the Malamans say that we all learned about in law school. At its core, though, we had this banking industry that said, we are accepting. It is not fraudulent to tell us what you anticipate income is going to be. Just put it down there. We brought in, Mr. Benchick brought in at trial the loan officer who worked with Washington Mutual and said the underwriters were authorizing us to accept all of this. And he literally said at trial, if you thought you were going to win the lottery, you could tell them, I think I'm going to win the lottery. Now, we're not here. That's an extreme. But Mr. Benchick had signed contracts from legitimate investors on deals that were supposed to close next week. How is that any different than if I have a client I've signed a contract with who says, great, I'll be in your office on Friday with a cashier's check for your service?
The problem is the supposed to close.
Yes.
That may be where the intent was found, that perhaps it wasn't very persuasive to view these as supposed to close. I don't know. Obviously, the jury had that option.
Mr. Benchick was ill-advised in that or not, whether he was being optimistic. The government never challenged any of that. Mr. Benchick put on proof of these deals. It was uncontested that they were supposed to generate money. He put on evidence as to how much money similar deals had done in the past. He was a real estate investor with his father who had been rolling in the good for years, making money like everybody had, including Washington Mutual and National City, until the crash. And then all of a sudden you can't make these payments because the next deal didn't close because the bottom fell out. But our point is that that doesn't equate to fraud. Now, if I could segue to the unanimity instruction, I would like to respond to you, Judge Gibbons. This was not charged as just some general effort to get money out of him. There were two schemes. That's the way it was presented. And on different days, they would talk about real estate. On different days, they would talk about Bev. I get why the government wants to say, on this day they talked about both, therefore they're together.
Unanimity instructions are generally appropriate where you've got a situation where the statute in question specifies more than one way of committing a particular offense. That's not this case. This is a case in which it is alleged that there were two factual aspects of of a single scheme to defraud. And there's not, for example, let's say a drug dealer has more than one supplier. Single conspiracy, not three separate conspiracies if there are three suppliers. A single scheme. He just happens, there's some little factual variations.
Well, Judge, number one, this wasn't a conspiracy. Number two.
Well, it's not a conspiracy, But if you look at mail fraud, bank fraud, wire fraud, they're similar to a conspiracy in the sense that they're dealing, if it's a fraud conspiracy, they're similar in that they're dealing with an overall scheme to defraud.
I would agree with that, Judge, though there have been a lot of duplicity cases that have talked about somebody who had, for example, a cocaine conspiracy and a methamphetamine conspiracy, and they were separate, and the government had some issues when they proceeded together. Here, I would agree with you, Your Honor, and I think I've got a letter.
There's no bar on the government prosecuting more than one type drug in.
No, there's not, Judge. No more than they could have charged this in two separate counts, because, I mean, this is two separate frauds.
You think your client would be better off in that case?
We would know. This court would be better off. Do I know what would have happened in the jury's mind? No, I don't. But if I could, Judge, I'm out of time, but I'd like to just one more sentence.
I think we're
on your
fine in
answer.
either circumstance.
The Shad decision, Judge Scalia, that we cited to in our brief, points exactly to the answer. The government can't say, well, you assaulted X, is what Judge Scalia says on Saturday, and you assaulted Y on Sunday. Present that to the jury and then say, is the defendant guilty of assault? And a jury comes back and says, yes. Well, of which individual on which day? And that's exactly what we have here. All Your Honors need to ask yourself is, can we be sure 12 jurors unanimously found him guilty of fraudulent conduct related to the BEV or related to this? And we can't. And that's a duplicity issue, and that count needs to be struck. Thank you, Your Honors. I appreciate the court's time.
All right, thank you very much, and the case is submitted.
The counsel was CJA. Were you
Yes, Your Honor.
Oh, yes, indeed, yeah, we'd like to thank you for taking the case under the Criminal Justice Act.
Of course, Judge.
No, you do that as a service to the court and its system of justice. Thank
Happy
you
to
very
serve.
much.
Thank you, sir.
Thank you.